Your figures of speech include the following. She's a bitch.
Objection.
Is that right?
Yes.
9 months after he embarrassed himself and the state police on a national stage, Michael Proctor's career as a trooper ends with the dishonorable discharge. State Police Colonel Jeffrey Noble made the call after a disciplinary panel found Proctor guilty of sending derogatory, defamatory, and disparaging text messages about Karen Read and showing bias while investigating her for the death of John O'Keefe. Colonel Noble says his decision to terminate Proctor follows a thorough, fair, and impartial process. He says he's confident that Proctor's termination will stand even if Proctor chooses to appeal. I'm investigative reporter Ted Daniel for your local station, Boston 25 News.
Well, we just heard the news, and that was on the 19th of March, 2025. The Department of State Police Trial Board found the lead investigator, Trooper Michael Proctor, in the Karen Read investigation guilty of direct violations to work standard policies and was terminated with a dishonorable discharge. This, in employment terms, means fired, and a dishonorable discharge for a police officer would mean they would be barred from future employment in law enforcement, and the reasons for this decision would be made public. So let's have a closer look at the publicly released trial board findings that we just heard about. You can find a copy on tbdailynews.com. So we can see 2 charges and 4 guilty outcomes on the specifications, which are the details of the direct violations. Out of the charges I find most interesting on the dates between the 29th of January 2022 and August 17th, Proctor did fail to conform to work standards established for members' rank, title, or position, and did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. This occurred when Trooper Proctor, while assigned as lead investigation on a homicide investigation, through his unprofessional and inappropriate conduct, created an image that he was biased in his dealings with a homicide suspect, or brought otherwise himself and Massachusetts State Police into disrepute. So if we go back and just read what they are actually saying, they're saying that he failed to take appropriate action, and this is something that the defense can utilize in Karen Read's defense. And they are also saying that it created an image of bias. Whether or not it was is, I suppose, up to a jury to decide. So let's continue. So I can tell you, every governmental service that I've worked for, our contracts do say that if you bring disrepute to the service, or even the image of disrepute, you could be fired immediately without notice. And we also sign a contract to say that we will not share our work product with the outside world, and without permission. The other charge, which I think is worth noting that Michael Proctor was found guilty on, was sharing sensitive information about a homicide victim, potential witnesses, and potential investigation steps in the investigation to non-law enforcement personnel. So that's a very serious charge, and we're going to get into how this could affect Proctor being able to testify and what could he testify about. If you are interested, I have done a video on offensive communications and warnings from the Ministry of Justice in the UK, because disrepute means giving a bad reputation to the service you represent. So back to the misconduct from Trooper Michael Proctor. The last charge was drinking while on duty. So for our purpose, I think the first 2 charges are going to help Karen Read's defense, sharing information and being biased. So let's talk about bias. Would it be bias if his wife was friends with Jen McCabe, who is the sister of Brian Albert's wife, where John O'Keefe's body was found unresponsive in the front lawn? Do you remember Jen McCabe's testimony? It was the Canton police who were first on scene, and Jen McCabe called 911. I found it odd that she wasn't screaming for police to check that her family was okay. Instead, she was calm when she was talking to 911. And if you think about it, if you came across a friend on your front lawn or on your sister's front lawn that you had been out with the night before, unresponsive, in the condition John O'Keefe was found in, wouldn't you be scared something could have happened to your family inside the house? This is why I think Jen McCabe was searching Hal's Long to Dying Cold at 2:27 a.m. because she knew at that time something had happened. And that aligns with the plethora of butt dials that night. And I go through it in these videos. So in Canton, Massachusetts, the police hand over cases that deal with death investigations to state troopers, and this is why State Trooper Proctor was assigned to investigate this case. He did not think his connections to Jennifer McCabe were worthy of telling his higher-ups or the Commonwealth DA or prosecutor or recusing himself. Here, let's have a listen.
Don't know most of the Alberts, and I have little to no relationship with Chris and Julie. So that's what I meant by that answer.
Well, the question wasn't, did you know most of the Alberts? The question was, did you have a relationship with, or did you know the Alberts? And your answer was, no.
No, I don't have a relationship with the Alberts.
Or know them.
I don't know the McCabe's. I don't have a relationship with the Alberts.
So you do know the Alberts, correct?
I know some of them, Julie and Chris.
And Colin, correct?
Correct, and Colin.
And you knew the Alberts when you gave this testimony in February of 2024. Is that right?
Yeah, they asked if there was any relationships.
And let's try this again. Meaning you told First Assistant Beeland that you didn't have relationships with members of the Alberts members of the Albert and McCabe families. Answer, correct. Mm-hmm. Was that ambiguous in your mind?
The way I interpreted relationships was basically being like friends or, communications, frequent communications. That's how I interpreted it.
Well, that might have been a good time to pipe up and say, well, I know Chris and I know Julie and I know Colin, correct?
Objection.
Sustained.
That might have been a good time to answer the question, I know these three individuals from the Albert family, right?
Objection.
Sustained.
But your answer was one word, correct, right?
Yes.
You further testified that you never have gone to any supervisor at Massachusetts State Police to disclose even a potential conflict of interest in this case that you might have, correct?
Correct.
And you indicated the needs never come up. Is that right?
Correct.
You also told ADA Lally that you, quote, did not have relationships or know members of the Albert or McCabe families, correct?
Correct.
And that's just not true, is it? You do know members of the Albert family. Isn't that right?
It's different from having a relationship with people.
But what about part of the question, did not have relationships or know members of the Albert or McCabe families? How about that part of the question?
Well, that's lumped in with the McCabe's. I don't know the McCabe family, sir.
I see. So what you did, Trooper Proctor, is you dissected the sentence. And where relationships are concerned, you ignored that in terms of the Alberts because you don't have relationships. Where no is concerned, you link that to the McCabe's because you don't know the McCabe's. That's what you did?
No.
So it's sustained. You can ask it. You can break it down, Mr. Jackson.
Not sure I can. I'll ask it a different way. How about if I just ask it this way? That was a lie, wasn't it?
No, absolutely not.
You stand by that testimony?
Yes.
That you don't know at the time that you testified, that you didn't know the Alberts or any members of the Albert family?
I don't have relationships with them.
Okay. My question is, you keep going back to relationships. I'm asking you, did you testify that you didn't know them?
Objection.
I'll let him have it. Do you understand the question, Trooper?
It was Chris, Julie, and Colin.
So if you were to say, I don't know any members of the Albert family, that would have been a lie, correct?
Objection.
Sustained. Have you seen that?
I can't recall.
Next question.
After you wrote, she hit him with her car, 5051 writes, oh, Jesus. And Bird writes, okay, that's fucked up, correct?
Correct.
And then you wrote what?
Intentional or not?
Intentional or not? Is that right?
Yes.
Your words.
Correct.
0095 then chimes in, gotcha. He was frozen in the driveway and she didn't see him? Question mark, correct?
Correct.
And you wrote what?
That's another animal we won't be able to prove.
That's another animal we won't be able to prove, correct?
Correct.
Trooper Proctor, you knew that there were going to be things in this case, even 16 hours into this, that you just admitted you would have zero proof of, correct?
Objection.
Sustained. You can ask it differently.
Did you mean by that statement that this was one of several things that you knew we would not be able to prove?
That statement, that's another animal we won't be able to prove, references the intentional or not part.
You didn't care at that point, when you wrote that, you didn't care what you could or could not prove, did you?
Objection.
I'll allow it.
Isn't that what you meant?
No. I
had a narrative that you had developed, and you would pursue it no matter what the proof was. That's what you meant by that statement, correct?
objection.
Sustained. You can ask it differently.
Did you mean by that, thank you, Your Honor, I didn't mean to step on your words. Did you mean by that statement that you were going to pursue this case no matter what the proof might be?
What I meant by that statement was if Miss Read backed into Mr. O'Keefe intentionally or not.
Interestingly, though, that statement came on the heels of he was frozen in the driveway and she didn't see him. And you wrote in response to that question, that's another animal we won't be able to prove. Correct?
That's not what I was responding to. I was responding to the intentional or not part.
So you're responding to your own statement?
Correct.
Okay.
Proctor knew the Canton police were conflicted because the homeowner, Brian Albert, was a Boston police sergeant who was assigned to the fugitive unit until he retired in September of 2023, some 7 months after the victim, John O'Keefe, was found unresponsive on Albert's front lawn. John O'Keefe was a fellow Boston police officer for 16 years. In my opinion, the lead investigator should have recused himself, but we are where we are, and the retrial of Karen Read is going forward. The defense attorneys in the first trial questioned Proctor, but they spent a lot of time establishing did he have a relationship with Jennifer McCabe and her family through his wife, which Proctor disagreed with, and he said that the relationship he had that his wife had no bearing on his ability to carry out a fair investigation when it came to the evidence pointing to Karen Read hitting John O'Keefe with her SUV. Yet he was texting his friends and family about the incident. He had not properly investigated all persons of interest, especially the behaviors of the people who were out with John O'Keefe at the bar at the night in question. And the same went for those who were at the house party celebrating Brian Albert's son, who I believe was turning 18. And John O'Keefe and others at the bar were invited back to Brian Albert's house after the bar closed to have, a nightcap or whatever you do in the middle of the night in a snowstorm. Okay, but we'll talk about all that in a minute. So Proctor appears to have set himself up for plausible deniability, according to the defense, as he took advantage of the scene not being secured by Canton police until the state troopers could arrive there the next day. In his report, he mistyped the time he collected Karen Read's SUV from her parents' home, also the next day, which I discuss in this video, giving him enough time to plant the taillight pieces from Karen Read's SUV. Now, let's talk about the bias, as I think his hands are just about in every, part of this investigation. And I would have thought, as lead investigator, that he would have been concerned about the Canton police not getting a warrant to search the property, and why they were not concerned about the safety of the people inside the house. They could have made entry when the occupants inside the property did not come out. So I'm putting on the screen some videos that I've already done a deeper dive into the detail. And if you want to know more about Jen McCabe, as she was on the scene with Karen Read, and she couldn't get a hold of her sister when she first arrived. And this is why I mentioned, a little bit earlier, why wasn't she screaming for Canton police to do a safety check, even if, they didn't want to do one? So Jen McCabe, on her 911 call, had no concerns about her sister or her family. She was calm on the call, and she thought John O'Keefe had passed away. The defense is very concerned, and they feel that Proctor failed to investigate other possible suspects, and the defense wants to bring in a Bowden Defense to show the investigation did not adhere to the standard investigation policies and protocols in this case. They want to bring in an expert to testify. The investigation was not reliable due to the lack of securing the crime scene, absence of a detailed crime scene log or evidence chain of custody, and the failure to, separate witnesses. The premature categorization of individuals as witnesses, and the potential bias on the failure to investigate other suspects and obtain their cell phone records. So the defense wants to show all this with an expert to testify. The judge denied this. Are we surprised? Basically, the judge feels that the expert's report is not needed for the jury to determine whether or not the investigation was compromised by any failure to follow procedures or pursue other suspects. And the defense, she says, through zealous cross-examination of police witnesses, can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures, and can raise the issue of potential bias by the police action or inaction. And she says, as counsel did effectively during the first trial. I thought we were in a new trial. Anyway, an expert, according to the judge, is to assist the jury. And in this instance, the jury, in her opinion, can use their common knowledge as a lay person. So an expert is not being allowed to testify, and this decision is at the discretion of the trial judge. So some, courts do allow experts to obviously testify when it comes to complicated procedures or terminology or anything like that. Now, I find that odd because, I kind of think the average person on the street would not know how procedures should be done. So, So I think we're going to find that the defense will have to question the police a lot more as regards to their procedures and everything. So now you can understand why the testimony of Proctor and other police are going to be essential for this retrial to be even fair for Karen Read. But will Proctor be able to testify if he has been fired? I found a Massachusetts Legal Developments blog from an attorney at law in Massachusetts who answers this question. And the title is, Can a Fired Police Officer Give Reliable Testimony in a Criminal Case? He writes, and I'll only give you a summary of what I found interesting as he writes about many cases in Massachusetts that hinge on the testimony of police officers. But what happens when these officers are terminated or no longer employed by their department? If their testimony is necessary for prosecution, the criminal case becomes impossible to prosecute. Now, I found this quite interesting as he writes, impossible, yet the Commonwealth of Massachusetts is still prosecuting, or should I say persecuting, Karen Read. What is even more interesting is that he goes on to write that P.O.S.T, which stands for Peace Officer Standards and Training Commission, can decertify police. In doing this, may prevent officers from testifying in court due to their loss of their official position. And the Massachusetts State Police, along with peace officers in the Commonwealth of Massachusetts, are under the jurisdiction of P.O.S.T. Well, Proctor has been involved in a lot of cases, and he is on the Commonwealth's prosecution list. Will this change? If it does, the defense also has him listed. Will, Proctor be able to just say he cannot testify as he is prevented from doing so, because he doesn't have his files anymore? The defense should be able to bring up Mr. Proctor's previous testimonies as he testified in the grand jury and in the first trial. Notice how I referred to him as Mr. Proctor, as he is no longer a state trooper investigator. So, what happens if he testifies? I wonder if he's asked a question, will he say something like, I'd love to be able to answer you, however, I have no access to my files. Or will he just say, I can't remember? This was said a lot in the first trial by, police officers. So will his testimony be useless? What do you think? So the other thought that I had that might be interesting is to factor in the witnesses challenging the accuracy of Proctor's report. We heard a bit of that with Jen McCabe when she said, when she was testifying about where the cars were parked, she said, oh, well, I didn't say that, or, that's not how I recall, what I told Proctor. And will we see this a little bit more because the statements they gave to him were not video recorded? So will they end up throwing him under the bus and testify that is not what they said to Trooper Proctor? So would it be a benefit for the defense to call Proctor as a rebuttal witness to testify against the witnesses who said that he didn't get their statements right? What do you think about that? There's something else to think about here. Maybe Proctor will not want to take the fall because maybe he did tell his managers and the DA, certain stuff. Maybe he did disclose stuff to them and they're the ones that didn't disclose it, in court. So, will he want to take a different position now? Or will his appeal about being dismissed keep him from saying anything that would put his appeal in jeopardy? However, we did hear the news reporter say that the appeal is unlikely to succeed. This is going to be really interesting. By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.